The question is that the motion be agreed to.
Speaker.
I call the Honourable Member Giles Chevelle.
Thank you, Mr Speaker. Mr Speaker, the justice sector under this government is in a serious state of disarray, and one of the reasons for that state of disarray is the piecemeal approach that's been adopted to reform by this government in this sector. By my count, there are 8 ongoing reviews at a high level in the sector, ranging from issues concerning the way in which children should be giving evidence in court through to the way in which the prosecution service should conduct itself, right through and including a review of the bail system, legal aid changes, a review of the family court, regulatory gaps around new media, public feedback on legal aid lawyers. Sir, many of these reviews are not going to come to fruition or be completed under the term of this government and within this Parliament, and yet they are absorbing enormous amounts of time and energy in the sector and distracting people in the sector from getting on with their jobs, and in the case of the subject matter of this bill, caring for our most vulnerable children, which is something that should be a real concern to all of us. By my count, as far as the legislation affecting the sector is concerned, there are 11, counting this bill, 12 bills before the House at the moment in the sector with quite far-reaching significance as far as the reforms that they would enact are concerned. And Sir, I am very concerned about this piecemeal approach. As I say, it is distracting to those who are working in the sector. It is difficult to know with any certainty what reforms, legislative or otherwise, will be brought to conclusion at any time. It's difficult to keep up with the changes that are being made at any particular time, and certainly legal practitioners, counsellors in the court, those responsible for enforcing the law, all are feeling a significant level of disquiet as a result of all this turmoil and upheaval. And it would be much better, I think, sir, if we could see a coherent approach to reform, principles-based and comprehensive, rather than this seizing on issues by this government, which is what we're seeing in the sector, and a progression of this sort of piecemeal reform. And unfortunately, that's what we're also faced with this Crimes Amendment Bill number 2. Apart from the concern about this piecemeal approach to reform, there's also the fact that these reforms are going off to different select committees. The Minister in his speech proposes or foreshadows that he will be asking the House to send this bill to the Social Services Select Committee. Much of the other legislation relating to justice matters is either before the Justice and Electoral Committee or the Law and Order Committee. And I would like just to take this opportunity to ask the Minister to consider carefully whether or not the Social Services Committee is the appropriate committee or destination for consideration of this legislation. I would ask Mr Finlayson in particular to reflect on whether the alteration to the claim of right defence ought to be going to a committee such as the Social Services Select Committee. The committee surely is not the correct one to consider that question. That is a matter that ought to go, I would have thought, at least most obviously to the Justice and Electoral Committee. And if the Minister would like to think about that question, I think it would be a helpful one, a helpful thing for him to think about. It can't be a good thing for these reforms to be going off to different committees with varying levels of expertise on their ability to do Parliament's job and scrutinise them appropriately. Sir, as far as the major subject matter of the bill is concerned, it is undoubtedly the case that we have a problem with child abuse in this country. and we ought to address it. We ought to do everything we can to ensure that we take it seriously, we deal with it, and that we reduce it wherever we can. But one of the things that the Minister didn't deal with when he dealt with clauses 6 and 7 of the bill was the concern that's been expressed by a number of experts in the area that extended obligations around reporting and around liability for harm to children inevitably leads, as far as overseas experience shows, to covering these matters up, rather than actually leading to greater safety for children. The danger is that by further criminalising or further penalising people for failing to report concerns around the safety of children, the risk is that you drive the problem underground rather than bringing it to the surface and ensuring that those who need help in the system receive that help. So I think it is important to register that concern at the outset. It's always a nice feeling for parliamentarians to think they're doing something about a problem, but often the evidence indicates that in fact by applying a purported solution, it may well be that the situation is being made worse, and that is something that this House is going to have to think about very seriously as far as the provisions of clauses 6 and 7 are concerned, the ones that go to the heart of whether or not the safety of children is truly to be enhanced by the provisions of the bill. On the other operative provisions of the bill, it would appear that clause 5, dealing with the grooming offence, and clause 8, dealing with the concealed weapons issue, seem to be sensible reforms, although it is odd that they appear at this time and in this piecemeal bill. But I do want to spend some time on the claim of right issue, which is dealt with in clause 4. It wasn't a matter that was given great attention to in the Minister's speech, but of course we all know the origin of the attempt to confine the definition of the claim of right. This is done by clause 4(2) of the bill, and the relevant subclause reads, the definition of claim of right in section 2(1) is amended by omitting that the act is lawful and substituting at the time of the act of a proprietary or possessory right in property being property in relation to which the offence is alleged to have been committed. So in other words, a person asserting the claim of right defence has to have an interest in the property that is damaged in order to be able to successfully assert the claim itself. Now, this is clearly the government's reaction to the Waihopai spy base attack, where persons who were charged in connection with that attack were acquitted by a district court on the basis of the assertion of the claim of right defence. Lawyers in the House will know that the claim of right defence is an ill-defined one. It may well be that there is some benefit in looking carefully at its ambit, but doing so in the current circumstances is wrong. Clearly, legislating to change the law because the government has lost a court case rather than having pursued the other avenues open to it as a result of having lost that case not only seems like poor sport, it's not good constitutional practice. So, sir, there are some concerns, some real concerns about this bill, real concerns about the reference to the Social Services Select Committee, given some of the technical legal aspects that are going to have to be dealt with as this House looks at the questions more carefully that the bill throws up. The Labour opposition will support the first reading of the bill, but has real reservations, and I've set them out in my speech, sir.
I call the